case is in re A.G, M.G, L.G, M.A.G, L.E.G, and A.U.G. It looks like we have waivers by the appellee and one appellant, and we have one appellant mother's counsel here to argue today. So you'll have 15 minutes to present your argument. The argument is being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children and victims during your argument. You can refer to them by initials or terms like the child. We've read all the briefs and are prepared to proceed when you are.
Your Honor, may it please the court, Andrew Karras on behalf of the appellant Kimberly Kovar, the mother of the children in this case. When a dependency case ends with the return of a child to their parents and a return of the child to the legal custody of their parents and the closure of the case, and then new factual circumstances arise relating to the welfare of those children, are parents entitled to a trial to contest those new allegations before a court can terminate their parental rights? I submit that the answer to that question is yes, and because the juvenile court below held otherwise, we would ask this court to reverse. This case is, in a sense, about the quality and extent of a juvenile court's continuing jurisdiction over children who are adjudicated dependent post-closure of those cases. And that continuing jurisdiction is provided by statutory grant, that's Revised Code 2151.353F, and generally that enactment says that once a child is found dependent, once there's an order of disposition, any party can make a motion to modify that order of disposition until the child turns 18. Now, that said, nearly 30 years ago, the Ohio Supreme Court had occasion to construe that statutory language and essentially found that it is designed, that grant of continuing jurisdiction is designed to allow juvenile courts to continue to protect children, to make dispositional orders in accordance with their best interest as necessary, even in the face of statutory and other procedural filing deadlines not being fulfilled. But nevertheless, and here I'm quoting from the In re Young Children case that we've cited in our brief, where the original problems have been resolved or sufficiently mitigated, courts may not make further dispositional orders based on the original complaint. Again, I would submit that that is what happened here. This was a post-closure case brought pursuant to a motion, not a new complaint, but a motion to modify disposition with no fresh complaint being filed, and more to the point with respect to our standard of error, no fresh determination of dependency, neglect, abuse, or...
That motion clearly alleged new facts.
Certainly.
It wasn't go back to the old complaint, it was alleging new facts. So if instead of calling it a motion, they had called it a complaint, would you say, in your view, that satisfied statute?
So if it had been styled as a complaint, and obviously there are ways in which a motion by its terms doesn't, it's styled differently. There aren't numbered paragraphs, there aren't pleadings. But certainly the thrust of our complaint is the lack of a new opportunity to adjudicate the facts of those complaints. It's not really centered on the form of that initiative.
That could have been adjudicated, but your client waived that.
Well...
and you questioned how the waiver was done, but there was an opportunity for a hearing, and your client waived that.
So a couple of things about the nature of that hearing. One, there's some dispute on the record about what the nature of that hearing was. Parents' counsel both said that it was at least their subjective understanding that they were there for a probable cause hearing, for a shelter care hearing. The timing of that hearing was consistent with shelter care, and at least there's some indication in the way, and maybe this reflects the clerk's work rather than the court's, that it was, that scheduling notices described it as a shelter care. Now, to be sure, there's some countervailing indications in the record. The magistrate described the hearing as a motion hearing in the magistrate's order memorializing that hearing, and both parents executed trial waivers. No,
And
by
there
its
are
terms.
signed waivers in the record for us to review.
Yes, so,
But there's no transcript of the hearing that took place on that date. Am I fair in saying that?
that's correct. That's not part of the appellate record. Those waivers, so it's document 323 and is mother's waiver, and I apologize, but father's waiver, which is substantially identical, it has father's initials instead, is immediately adjacent to it in the record. Now, those waivers by their terms are waivers of a dispositional trial. So ultimately, even though, as I said, there's some indication that it's a probable cause hearing, some indication that it's a dispositional hearing, irrespective of whatever the nature of that hearing was, it's clear that it wasn't an adjudicatory hearing. It wasn't a hearing held for the purposes of whereby the parents had the opportunity to contest the truth of the facts in the complaint.
Right, if it's styled as a motion, even if you construe it as a complaint, the normal procedure was not there. There's not an allegation of dependency, neglect, or abuse. There's not a adjudicatory hearing that you could appeal.
That's correct.
There isn't a case plan that's adopted, and there isn't a sunset dispositional date.
So there is a case plan eventually adopted in the case, but I don't believe it was at that hearing that was held, again, approximately a day after this motion was filed.
Your view on this, at some point in time, the court had to make a finding of suitability.
Correct.
And at some point in time, they had to make a finding of change of circumstance.
Correct.
Was that time in this case, in the December 23 hearing, or is your position that still could have been argued in April of 25?
So I think it could have been argued in April of 25.
Was it argued in April 25 that there wasn't a change of circumstance and the parents were still sued?
So father files a motion to dismiss, and indicates to the court throughout kind of the life of the case that he intends to file that, and I would have to check the record as to when exactly it was filed, but certainly ahead of the permanent custody trial. And to your point, have we sketched out in the brief, exactly when this fresh adjudicatory hearing, when the right to that hearing arises? I don't know that we've sketched it out precisely in our brief. I would answer that in kind of two ways. One, the case eventually proceeds to permanent custody, to a request for permanent custody. So given the liberty interests at stake, I submit there just has to be some sort of adjudicatory process before the case can proceed to permanent custody. And another way of understanding it is, well, who is making this post-closure request to modify disposition? It's the agency, which is the only party that would ever be entitled to eventually seek permanent custody.
If we took this to the logical conclusion, anybody who was involved with CSB with any complaint would be subject to having their child taken away without adjudication, even without a complaint with new facts and a procedure, right? So if your child was involved with CSB and there was a complaint filed and there was a disposition of custody with one parent or another when the kid's 2, then
Correct.
10 years later there doesn't have to be a complaint filed. There would just be some motions, right?
That's correct, and that is what this court's precedents, admittedly in a different procedural context in AS and in Re IS, would seem to imply that that implicit unsuitability determination that a dependency adjudication carries survives an award of custody, legal
Once
custody.
unsuitable, always unsuitable.
That's
While the child is under 18.
Yes. So
they had to show a change of circumstances, according to what our case law and that we've interpreted the statute.
certainly they did, and there was no express determination.
I understand the trial court did not find that, but there were no objections in regard to that or anything either.
No. That said, this court has so we've certainly, I think, preserved that issue at the very least for plain error review, and I've cited the In Re CS case from this court that in essence holds that it's plain error to proceed with disposition. It's error to proceed with a remedy hearing in the absence of a prior necessary liability hearing. And so it might be worth mentioning a case that the state or the agency brings up in its brief, the In Re N.G. case, that it says, well, you waive this issue by virtue of failing to raise it at this initial, post-closure reopened removal hearing.
Well, I think it's more than that. I think in NG and the state alleges not you just fail to raise it, but your client will actually waive these things on the hearing, and not just wasn't stated, but they signed specific waivers waiving a number of issues.
Right. So
what they seem to claim, although I don't think it shows that they waived a change of circumstance finding, but there is some level of a waiver of a hearing on this issue and proceeding to they not have a particular.
Correct. So again, it's document 323 in the record is mother's waiver, and it is by its terms a waiver of a dispositional hearing, which again that's a remedy hearing. It's it's not a liability hearing, and certainly there's another way of understanding the NG case. Well, it certainly addressed this circumstance, like what happens when there is no change of circumstances, finding that the statute seems to compel. There's another reason that the court ruled that way in NG, which is that was not even assigned as error by the appellant in NG. That discussion precedes this court's consideration of the appellant's assignment of error, and it's I think clear from NG that
NG noted that, but still went on to consider on the merits. I mean, they
Correct.
certainly addressed that same thing. They didn't say party presentation principle. They didn't say, hey, this wasn't raised by anyone, so we're not talking about it. They and NG noted, yes, it wasn't raised, but hey, let's talk about it and explain why this is a problem, but it was raised.
That's correct, and I don't know that the NG case talks about the specific terms of the waiver that was executed, but again, the waiver in this case was, by its terms, a waiver of a dispositional hearing.
And certainly in NG, they noted there was no finding of change of circumstance. There was not in this case.
Correct.
Did the state allege a change of circumstance in what they filed in this case?
So
In their motion for change of circumstance?
So they do invoke the statutory language in their, what was styled as a motion for emergency temporary custody. I believe that, yes, was at least a form of relief they requested on their written filing. That said, that there's no finding to that effect in the magistrate's decision or in the court's decision adopting the magistrate's order.
In these situations under 21, 51, 42, when custody has been given back to the parents and they're in the subsequent filing, does the statute indicate it should be a motion or a complaint, or does it give any guidance on that?
So it does, in general terms, say any party may make a motion for a modification of disposition. So our point isn't, the point of our first assignment of error anyway, isn't exactly that the court did something inconsistent with the statutory scheme. Really, the requirement that there has to be some, that the threshold at which the state can intrude upon the parent-child relationship is unfitness or unsuitability. That's a due process guarantee. That comes from, in this state, the Hockstock-Morales framework, as well as some of the federal precedent we've said in our brief. That operates, I submit, in conjunction with and kind of on top of the statutory framework. Certainly there's nothing in 2151 that says there must be a fresh complaint. But there does, at some point prior to terminating the parent's rights, there has to be some sort of unsuitability determination in one form or another before the rights can be terminated.
When you see custody change in this context, and there's a change of circumstances, it's usually custody to another third party involved. I don't know if I've ever seen one involving CSB asking for permanent custody in this situation. Do you know of any other cases where that has been the case?
No, we haven't identified any in our brief, and I couldn't identify one now. So I think
there's supposed to be a framework when we're talking about the government taking your children.
Correct, and I would say that to the extent that this court is obviously maybe perhaps loath to accept our suggestion that AS and IS should be reconsidered, there is a different liberty interest here, and I think this case can be distinguished on that basis.
Briefly on your time, you're almost up, but the state also argues harmless error in that if we were to reach the merits on this, there clearly was evidence that the children were, or that the parents were unsuitable, and there had been a change of circumstance based on the new complaint.
Sure, so the point I want to make, and this is related to kind of their merits point, I think that the permanent custody trial and a finding at either prong 1 or prong 2 of the permanent custody test serves as the unsuitability determination that I'm saying, mom and dad never got. And I think that's wrong for the fundamental reason that the permanent custody trial is, again, a remedy proceeding. It is about, even if the factual and legal analysis overlaps in some ways, it's a different hearing with a different purpose. So much in the same way that permanent custody is described as the death penalty of family law, I think it's fair to say that a permanent custody trial is a capital sentencing proceeding of family law. And in the same way that in a capital sentencing proceeding, the proof of the presence of one or more aggravating factors would overlap with the facts adduced at trial. For instance, the facts of the case would be something that demonstrates the presence of an aggravating factor. A permanent custody trial is just designed to do something different than prove or disprove the truth of the facts that led to the necessity of the removal. And because that was something the parents didn't get here, I would submit that this court should reverse and remand. Unless there are further questions.
The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and also the opinion will be posted on the Ohio Supreme Court. Thank you for your presentation.
Thank you.